pleasant day, everyone. My name is Nizel May Lumor, a student of Deva Winchester Colleges Incorporated, taking up the course of Bachelor of Science in Criminology, third year, Section 2. And now I'm just going to present my oral video presentation within the subject as CGL 3, Criminal Law in Book 1. So we have here questions that I am tasked to answer. So the first question is, what is a criminal? Criminal is defined as a person who has violated the penal law and has been found guilty of the crime charged upon observing the standard judicial procedure. Next question is, what is law? Law defined as the supreme power in a state through its legislature, commanding what is right and condemning what is wrong. Next question is, what is criminal law? Criminal law is defined as that branch of division of law which defines crimes, treats of their nature, and provides for their punishment. Next question is, what is crimes? Crimes is defined as an act committed or omitted in violation of public law forbidding or commanding it. Next question is, what is punishment? Punishment is defined as the redress that the state takes against an offending member of the society that usually involves pain and suffering. It is also the penalty imposed of an offender for a crime or wrongdoing. Next question is, what are the sources of Philippine criminal law? The following are the sources of Philippine criminal law. 1. The Revised Penal Code and its amendments. 2. Special penal laws passed by A. Philippine Commission, B. Philippine Assembly, C. Philippine Legislature, D. National Assembly, A. Congress of the Philippines, F. Batasang Pambansa. Next question is, who has the authority or has power to define and punish crime? Here are the following who has the authority or has power to define and punish crime. The state has authority or police power to define or punish crimes, lay down rules of criminal procedures. The right of prosecution and punishment for a crime is one attribute that by natural law belongs to the state. Such right is charged by the common will of society to defend interests of the community. Next question is, what are the constitutional rights of the accused according to Article 3, Bill of Rights of the 1987 Constitutions? These are the constitutional rights of the accused according to Article 3, Bill of Rights of the 1987 Constitution. In all criminal prosecution, the accused shall be presumed innocent until the contrary is proved, and shall enjoy the right to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy, impartial public trial, to meet the witness face to face, and to have compulsory process to secure the attendance of witnesses and the production of evidence in his behalf. However, after arraignment, trial may proceed, notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. The last question is, what is the statutory rights of an accused according to Section 1, Rules 115 of the Revised Rules on Criminal Procedure? Rule 150, Rights of Accused, Section 1, Rights of Accused at trial, in all criminal prosecutions, the accused shall be entitled to the following rights. A. To be presumed innocent until the contrary is proved beyond reasonable doubt. B. To be informed of the nature and cause of the accusation against him. C. To be present and defended in person and by counsel at every stage of the proceedings, from arraignment to promulgation of the judgment. The accused may, however, waive his presence at the trials pursuant to the stipulations set forth in his bail, and his presence His presence is specifically ordered by the court for purposes of identification. That the absence of the accused without justifiable cause of the trial of which he had notice shall be considered a waiver of his right to be present thereat. When an accused under custody escapes, he shall be deemed to have waived his right to be present in all subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his right without the assistance of counsel. D. To testify as a witness in his own behalf but subject to cross-examination on matters covered by the direct examination, his silence shall not in any manner to prejudice him. E. To be exempt from being compelled to be a witness against himself. F. To confront and cross-examine the witnesses against him at the trial. Either party may utilize as part of its evidence the testimony of a witness who is deceased, out of or cannot, with due diligence, be found in the Philippines, unavailable or otherwise unavailable to testify, given in other case or proceedings, judicial or administrative, involving the same parties as subject matter, the adverse party having the opportunity to cross-examine him. G. To have compulsory process issued to secure the attendance of witnesses and production of other evidence in his behalf. H. To have speedy, impartial, and public trial. I. To appeal in all cases allowed and to the manner prescribed by law. And that would be all the questions for this subject, Criminal Law, Book 1. Thank you for watching.